Greetings and welcome to another installment brought to you by Mohamed Marrzooqi Advocates and Consultancy, leading legal experts. Legal mechanisms deal with the work injuries and occupational diseases in accordance with the United Arab Emirates Labour Law number 8, 1980 and the amendments. The first article of the UAE Labour Law defines the work injury as the injury of a worker to an occupational disease in the schedule attached to this law, or any other injury arising from his work obtained during the performance of that work and because of it, and in the case of the injury at work, every accident occurring to the worker during the period of going to work or returning from it, provided that the return and go without interruption or failure or deviation from the natural path. Therefore, an injury at work is solely that the injury occurred to the worker during the performance of his work, such as dropping a piece of metal on his foot, for example, or contamination from toxic gases, such as working at a petrol station due to the nature of the work. A work injury shall also include any injury or accident to which the worker is exposed to in the normal course of his work. A work injury shall not be considered if the worker is injured in an accident outside the official working hours. In this case, his destination is not his place of work. The law classifies occupational injuries and occupational diseases with two tables attached to the labour law. First table includes the poisoning with minerals, sulfur, phosphorus and petroleum derivatives, as well as incurable skin diseases, eye diseases and other. Whilst the second table includes cases of paralysis and loss of senses and loss of limbs, even the smallest parts. In the event of any work injuries, the UAE Labour Law specifies the procedure to be taken in the workplace, which is to inform the police and the Labour Department of the accident and its circumstances after providing first aid to the injured. Article 142 states the following. If the worker is injured by an occupational disease or injury, as shown in Table 1 and 2 attached to this law, the employer or his representative should immediately notify the police department and the Labour Law Department or one of its branches located in its place of work, and it shall include the worker's name, age, occupation, address, nationality, a brief description of the incident and its circumstances, and the measures taken to remedy or cure it. Once the communication arrives, the police shall carry out the necessary investigation. The witness, employer or his representative and the statement of the injured person shall be recorded in the records if his condition so permits it. The minutes shall indicate in particular whether the incident is related to the act and whether it was committed intentionally and as a result of gross misconduct by the worker. It's clear from the text of this article that the law requires the police department to conduct a full investigation to hear the statements of the witness from the employer to the other workers and colleagues of the injured worker, and even the worker himself if his state of health allows it. This is in order to know all the circumstances of the incident that caused injury. The importance of the investigation is to determine whether the circumstances of the incident was it a fatal accident, or because the weakness of the industrial security measures in place in the establishment, or because of the negligence of the worker, perhaps distracting himself from his work. In rare cases, the accident may be done intentionally by the injured person. After the investigation by the police department, a copy of the record shall be sent to the Labour Department and another to the employer, as stated in the text of Article 143. Upon completion of the investigation, the police shall send a copy of the record to the Labour Department and another to the employer. The Labour Department may request the completion of the investigation, or it may complete it immediately if it deems necessary. We note from the text of the article how the law gave the Labour Department the power to request completion of the investigation or to complete its own, and this does not seem surprising. It is part of the law to clarify the truth, and the investigation of the work department is so incident is seen from another angle, a purely working angle. When the worker enters hospital, the law states all the costs of treatment are at the expense of the employer. This is logical, as the worker has given his efforts in favour of the company. This is confirmed by Article 144. Which states, in the case of occupational injury and occupational diseases, the employer shall pay the expenses of treating the worker in one of the government or local government treatment rooms until the worker is cured or proven incapacitated. The treatment includes hospital stay, medical examinations, surgery, photoradiation expenses, as well as purchase of medicines and rehabilitation equipment and the provision of limbs and prosthetic devices in respect of incapacity, and the employer as well as the foregoing to pay the transfer expenses required by the treatment of the worker. In the case the injury of the worker is so serious that it prevents him from continuing his work, the law requires the employer to provide financial aid to the injured. The amount depends on the nature of the contract that existed between the worker and the employer. The worker should receive a monthly wage or a daily pay until he has recovered from his injury. If the period of treatment lasts longer than 6 months, the financial aid provided by the employer shall be reduced by half in the next 6 months or until he's recovered or it's proven that he has a disability. This is clarified in Article 145 and states, if the injury between the worker and the performance of work, the employer must lead to a financial aid equivalent to the full fee for the duration of the treatment, or for 6 months, whichever is shorter. If the treatment took more than 6 months, reduced aid by half for another 6 months or until the recovery of the worker, or proves his disability or dies, whichever is shorter. As for the worker who is paid by a piece, financial aid is the average daily wage provided for, clarified in Article 157, and states the daily wage shall be calculated for the worker who are paid on a piece-by-piece basis on the average of the worker's actual working days during the 6 months preceding the end of service, in accordance with Article 146 of the law. The mentioned articles indicate that the labour law, specifically with regards to work injuries, is detailed and precise in its provisions. Most importantly, it puts the workers' health and safety above all other considerations and has provided legal protection to workers in the event of a work injury. So today's video is brought to you by Mohamed, Al-Marzuqi Advocacy and Consultancy, leading legal experts. We have offices in Abu and Dubai. We are waiting for your call. Please contact us for your consultation. Otherwise, you can visit our website, which is www.ml-advocates.com.